The Road Not Taken, Johannes Althusius. Part 2, City, Realm and Sovereignty. In the previous lecture, we saw that Althusius agreed with Baudin's account of sovereignty, except in regard to its location. Sovereignty belongs to the people and is inalienable. Althusius distinguished 5 types of association or consociation linked to each other like circles within circles or Russian dolls. These 5 consociations were the family, the collegia, the city, the province and the realm. The first form of the mixed and public forms of consociation is the community or city. A city is not constituted directly from a mass of isolated individuals. Such a mass is more properly called a crowd, a throng, a multitude, or a gathering. Rather, the city is a public consociation of private consociations constituted by fixed laws and a commonality of residence. The public association or consociation exists when many private associations or consociations are linked together for the purpose of establishing an inclusive political order. The members of a community, a city, are private and diverse associations of families and collegia, not the individual members of private associations. As with all other forms of consociation, the city has a president or rector. As such, he directs the business of the community and governs on behalf of its welfare and advantage, exercising authority over the individuals but not over the citizens collectively. You will note the identical structure and function of the rectors of collegia and rectors of cities. They exercise their authority for the attainment of the ends of their respective consociations, but while superior to their individual constituents, are nonetheless inferior to their constituents taken collectively. The rector of the city, who can of course be one or many, is such only by virtue of the consent of the civic community. The unity of the city is a unity of function and not of matter, and so continues in existence as long as that function continues to operate. There must of course be some rector and some constituent consociations composed of some particular individuals or other, but not any particular person or as rector or any particular consociations, nor indeed any particular individuals. Althusius envisages a city of any reasonable magnitude as having not only a rector but also councillors and senators whose function it is to advise and assist the rector, and who, in so doing, constitute a senatorial collegium. We shall see, when we come to consider the universal consociation, that is the realm or the commonwealth, that those who there comprise the commonwealth, equivalent of the senatorial collegium, also assist and advise its rector, but significantly also have functions of supervision and ultimately control over the rector. Just as with the family and the collegium, the community or city lives its life in common and its component parts communicate with each other with respect to things, services and constitutive laws. These things, services and laws are necessarily more extensive and more complex than those obtaining in the constituent consociations, but their function is identical. Among the services that Althusius has in mind are the activities of carpenters, builders, shoemakers, tailors and the like, all specializing in their work but all contributing to the common advantage of the city. The political functions of a city relate to justice, the essence of which Althusius sees outlined in the second table of the Decalogue. More on this later, when we come to discuss the Commonwealth. Althusius' treatment of the province as an independent level of consociation is perfunctory, a fact that becomes less surprising when one realizes that the province made no separate appearance in the first edition of the Politica, but was treated rather as an administrative and constitutive element of the Commonwealth. There is little to distinguish the province from the Commonwealth in terms of its function, except its having a superior consociation to which it is subordinate, which is as much as to say that it is not sovereign, and in its having existed in its own right before commonwealths. For families, cities and provinces existed by nature prior to realms, says Althusius, and gave birth to them. The realm or commonwealth, Althusius refuses to make a distinction between the two, is the form of universal consociation, a people united in one body by the agreement of many symbiotic associations and particular bodies, and brought together under one right. The immediate consociations that make up the Commonwealth are cities, provinces, and regions which are to the Commonwealth as prow, stern, and keel are members of a ship, and roof, walls, and floor are essential parts of a house. Once again, the foundation of this consociation is not a mere collection of units, but a consensus which Althusius describes as a tacit or express promise to communicate things, mutual services, aid, counsel, and the same common laws to the extent that the utility and necessity of universal social life in the realm shall require. He spoils the bracing effect of the notion of consensus when he adds that the reluctant are compelled to comply with this communication. The commonality of laws in the Commonwealth as a whole does not prevent there being different special laws in the provinces. Althusius sees danger in either an excess or deficit of population in any given Commonwealth. Too many people, and there is a danger of corruption, as happened with Rome. Too few, and the Commonwealth's safety is compromised. It is in respect of sovereignty that Althusius differs sharply from Boda, and had the Althusian and not the Bodinian conception of the location of sovereignty prevailed, the course of political history might well have been very different. Both Althusius and Boda agree on what sovereignty is. Althusius defines it as the universal power of ruling, which recognizes no ally nor any superior or equal to itself. The essential difference, to state it boldly, is that for Althusius, sovereignty belongs to the people in their universal association, and not, as it does for Boda, to the chief officer of that consociation. Sovereignty does not belong to any single member of the realm, immediate or distant, but jointly to all. Althusius is aware of Boda's thought, of course, and knows well what is at issue. He acknowledges that both he and Boda would accept that a human sovereignty has a superior in divine and natural law. Is civil law superior to sovereignty? Well, Boda says no. There is a supreme power above civil law, and not limited by it, but, Althusius continues, this is a judgment I would not hold. To liberate power from civil law is to release it to a certain degree from the bonds of natural and divine law. For there is no civil law, nor can there be any, in which something of natural and divine immutable equity has not been mixed. If it departs entirely from the judgment of the natural and divine law, it is not to be called law. To the extent that civil law partakes of a higher law, to that extent it is superior to the sovereign. However, where civil law departs from this higher law, then the sovereign is not necessarily bound by it. Does this concession grant Boda all that he needs? No, because Althusius does not locate supreme power in a king or optimates, but grants it only to the body of a universal association. From this body, after God, every legitimate power flows to those we call kings or optimates. Therefore, the king, prince, and optimates recognize this associated body as their superior. It wouldn't be going too far to say that for Althusius, the ruler is an agent of the Commonwealth, which is and which remains his principle, and not the other way around. As an agent, the ruler is limited by the terms set by his principle, and must render an account of his administration to this principle. As an economic agent may not willfully diminish his principal's capital, so too the ruler may not alienate the provinces or cities or towns of the realm. In the extreme, just as an agent serves at the pleasure of his principal, so too the supreme monarch may even be deposed. Another way of thinking about this is to see it in terms of the trustee-beneficiary relationship. A trustee is vested with all the legal ownership of the property of its equitable owners, but he must exercise his legal ownership for their benefit and not for his own benefit. Althusius makes the point very clearly that political power is given not for the advantage of the persons who exercise it, but for the advantage of those entrusted to their care. Universal administrators and their deputies, delegates and ministers have the use and exercise of power for the benefit of others, not the ownership of it. It must be remembered that Althusius is a Calvinist, and so it's not perhaps surprising to find that his commonwealth has rights not only over the body, but also over the soul. The true and right religion can be ascertained by the Word of God, and the commonwealth has the right and power to restore this faith if it should be corrupted, and, somewhat more alarmingly, the right of expelling from the territory those alien to uncorrupted religion, and, even more alarmingly, of compelling the citizens and inhabitants of the realm by public ordinances and even by external force to worship God. Religious toleration is then not an aspect of the Althusian commonwealth. Atheists or doubters cannot be tolerated. There is only one God and only one right way to worship him, so that many faiths and many diverse churches introduce idolatry and impiety. The core of public law is to be found in the second table of the Decalogue. It prohibits homicide and the infliction of bodily injury, offences against chastity, property, and reputation. More local laws may vary according to the varying circumstances of place, time, and person within the Commonwealth. The material necessities of life in a Commonwealth require that there be regulations that facilitate commerce, sound money, a common medium of communication, and the equitable allocation of duties and responsibilities. All of this supported by ordinary taxation or, in cases of emergency, extraordinary taxation. Because the Commonwealth, like all consociations, is based on consent, none of these conditions is necessarily problematic for a libertarian, provided that the consent is real and continuing. Finally, the Commonwealth is entitled to use force to defend itself against violence and rapine and theft, and to preserve liberty, all this being defensible on libertarian grounds. But the Commonwealth is also entitled to use force to defend the true religion and to produce a rite of passage for its citizens through foreign territory, if it adjudges that permission to do so has been unreasonably withheld. These latter justifications of force not being defensible on libertarian grounds. Finally, the Commonwealth requires councils to determine general policy issues such as the Commonwealth's fundamental laws and the imposition of taxes, because what concerns all should be acted on by all. Furthermore, there is wisdom in crowds. And still further, the executive officers of the Commonwealth are held in check by a fear of such councils in which complaints can freely be heard, and the administrators are required to give an accounting of their administration. As is the case with all forms of consociation, the consociation that is the realm is formed by agreement, in this case an agreement on the basic laws. These laws, however, must be administered, and to this end certain administrators or rectors are chosen and entrusted with this task. The relationship between those electing the rectors and the rectors thus chosen is twofold. The electors, taken as a whole, are superior to the rectors and are indeed their masters, for the Commonwealth or realm does not exist for the king, but the king and every other magistrate exists for the realm and polity. On the other hand, the individuals constituting the electors are subjects of the rectors. By way of analogy, one might say that the electors as a whole are the beneficial owners of the rights of the Commonwealth, while its rectors and its trustees are legal owners. A king, then, can be said to be above and below his subjects. He is below his subjects taken collectively or corporately. He is above his subjects taken individually. Therefore, these persons, Caesar, king and prince, are over in one relationship and are under in another, but not over and under in the same relationship. They are nevertheless over and under at the same time and with reference to the same interpretation. If rectors, rulers, or kings exceed their authority, they lose their status as rectors and revert to being private persons, so that they are not owed obedience in these matters in which they are acting ultra vires. They can exceed their powers in at least three ways: by commanding that to be done which is prohibited by God, or by commanding that to be omitted which is required by God; by commanding that to be done which is contrary to charity, or by commanding that to be omitted which is required by charity, and by seeking their personal profit instead of the good of the realm. Sovereignty, which is the supreme power of doing that which relates to the spiritual and material welfare of the members of the consociation, inheres in the people taken as a whole in its corporative existence. Magistrates and kings are functionaries who are subject to the people as a whole. The king or chief magistrate is an executive of the sovereign power of the people. The relationship between king and people is asymmetrical. The king's obligation to the people is absolute, while the obligation of the people to the king is conditional. Should the king fail in his duty and descend into tyranny, the people may resist and even depose him. Private individuals are limited to passive resistance to such commands as are unlawful and self-defense against the invasion of natural rights. Althusius conceives of two kinds of rector, ephors and the supreme magistrate. Ephors are the representatives of the Commonwealth who are entrusted with the task of appointing the supreme magistrate and in assisting him once appointed. They are chosen by the consent of the whole people. The ephors also exercise a supervisory role, ensuring that the supreme magistrate acts within his powers and does nothing that is ruinous or detrimental to the realm. In case of need, they can remove a tyrannical supreme magistrate. They also act as de facto administrators of the Commonwealth in the event of an interregnum brought about by the magistrate's captivity, death, insanity, prodigality, or any other impediment that should incapacitate him. Althusius's ruminations are not purely theoretical, but are to a certain extent a codification of the existing structure of the empire. This becomes clear when he says that in the German polity such general efforts are the electors, or the 7 men of the imperium, of which 3 are ecclesiastical and 4 secular. The ecclesiastical are the Archbishop of Mainz, the Archbishop of Cologne, and the Archbishop of Treves. The secular ephors are the King of Bohemia, the Prince of the Rhenish Palatinate, the Duke of Saxony, and the Duke of Brandenburg. Ideally, a commonwealth or realm will have ephors, but where it does not, then the functions of the ephors are undertaken by the consent of the entire people, proposed or obtained by tribes, by curial or centurial divisions, or individually. A covenant or contract subsists between the supreme magistrate and his subjects, which imposes obligations on both parties. The obligations fall first upon the supreme magistrate and then upon the subjects, for the people can exist without a magistrate, but a magistrate cannot exist without a people. The people creates the magistrate rather than the contrary. Failure on the part of either party to observe the terms of the covenant releases the other party from its obligations. The supreme magistrate exercises only those powers that have been explicitly conceded to him, and cannot exercise absolute power. Althusius believes that absolute power could serve only the pleasure of the supreme magistrate, and, if exercised by any magistrate, would destroy justice. And were that to happen, then, echoing the words of St. Augustine, the realm would become a band of robbers. In fact, the supreme right in any commonwealth cannot be communicated to anyone, not even the supreme magistrate, and remains with the body of the universal association. In taking the approach Althusius does to the supreme magistrate, Sabine believes that he continued and elaborated the anti-royalist theory of the French Calvinists. An interesting development resulting from Althusius' theory of the composition of the state, not from individuals but from larger bodies, is that, in the event of a breach of contract, such bodies may withdraw from the state. This amounts to a justification of secession. The Politica contains an interesting but not particularly novel account of law. What the Politica does contain, however, is a chapter on tyranny, a chapter which did not appear in the first 1603 edition of the work. A ruler does not become a tyrant simply because he is not perfect in the performance of his office. People vary in their abilities, and men, even rulers, are sometimes weak and irresolute. Even behaviour tending towards tyranny does not make a ruler a tyrant. Althusius observes that the wicked life of a magistrate does not invalidate his royal authority, just as a marriage isn't dissolved by every misdeed committed by one mate against another. Not every misdeed of a magistrate, he says, deprives him of his sceptre, but only that in which he, having accepted and then neglected the just rule of administration, acts contrary to the fundamentals and essence of human association, and destroys civil and social life. If a ruler does become a tyrant, either by overthrowing or destroying the fundamental laws of the Commonwealth, or by carrying out his functions in a manner contrary to piety and justice, what remedy, if any, is to be had? Well, resistance and, if necessary, deposition. By whom? Well, not by any particular ordinary citizen, but by the optimates or ephors, or, in cases where there are no ephors, by public defenders constituted ad hoc. In adopting this position, Althusius takes the more or less standard Calvinist line. He writes, "The position we have thus far taken about the ephors applies only to public persons. It plainly does not apply to private persons when the magistrate is a tyrant by practice, because they do not have the use and right of the sword, nor may they employ this right. This is to be understood, however, in such a manner that these private persons are not forced to be servants of tyranny or to do anything that is contrary to God. Under these circumstances, they should flee to another place so that they avoid obedience, not by resisting, but by fleeing. Nevertheless, when manifest force is applied by the magistrate to private persons, then, in case of the need to defend their lives, resistance is permitted to them. For in this case, private persons are armed against the magistrate who lays violent hands upon them by the natural law and the arrangements constituting kings." It should be evident from this that Althusius allows little scope for individual resistance to misbehaving rulers, except in respect of personal self-defense. You will remember that one of the functions of the ephors is to supervise the supreme magistrate. Althusius's justification of resistance to tyranny, even by the ephors, is far removed from the freewheeling account given by Buchanan, and it is hedged around with restrictive conditions. In resisting tyranny, the ephors must act as a body and not as individuals. The resistance must be, as far as possible, defensive rather than offensive, and even such defensive action must endure only so long as the tyranny endures, and only in respect of the ruler's actions, which are in fact tyrannical. For Althusius, a ruler has to behave exceptionally badly before tyrannicide is justified. In one instance only can he, the tyrant, justly be killed, namely when his tyranny has been publicly acknowledged and is incurable, when he madly scorns all laws, brings about the ruin and destruction of the realm, overthrows civil society among men so far as he is able, and rages violently, and when there are no other remedies available. One might be forgiven for thinking that if things have to come to such a pass before a tyrant can be killed, it is a case of too little, too late. Summary. Althusius adopts the Bodinian concept of sovereignty. However, sovereignty is to be located in the people taken corporately, not in the ruler. Althusius has a federalist conception of political order, or Daci. Politics is the art of consociating men for the purposes of establishing, cultivating, and conserving social life among them. Human society is constituted by an ascending order of consociations, all with the same basic structure: family, collegium, city, province, and commonwealth. Each consociation is created by agreement or contract and has a vertical and a horizontal dimension. For Althusius, the ruler is an agent of the commonwealth as a whole, which is and remains his principle. If rulers exceed their authority, they lose their status as rectors and revert to being private persons, so that they are not owed obedience in those matters in which they are acting ultra vires. If a ruler becomes a tyrant, he may be resisted and even deposed by the optimates or ephors, or, in cases where there are no ephors, by public defenders constituted ad hoc. Althusius allows little scope for individual resistance to misbehaving rulers except in respect of personal self-defense.